Provided that speech is lawful, content-based discrimination by the U.S. government is a First Amendment violation.
Correct.
So the fact that that speech is objectionable, again, provided that it's constitutionally protected, it's irrelevant to when you're dealing with government discrimination.
That's exactly right. Under the First Amendment, government officials don't get to decide what is objectionable or what is true and false. We get to decide that.
And it absolutely has to be that way. Otherwise, who polices the policers?
Absolutely right. This is the heart of the First Amendment.
Thank you. I yield back.
Thank the gentleman.
Mr. Chairman,
yields back. We now
Mr. Chairman, I ask for unanimous consent to enter 4 documents into the record.
Without objection, can you
Thank
identify the documents first, though? Can you identify the documents?
Sure. The first is a Time Magazine article titled, "Is This Texas County? There's No Such Thing as Moving on from COVID," from KXAN News in Austin. Do face masks work? Here are 49 scientific studies that explain that they do. From the Washington Post, an article titled, "The Inside Story of How Trump's Denial, Mismanagement, and Magical Thinking Led to the Pandemic's Dark Winter." And finally, a report published in PLOS Global Public Health by Peter Hotez, Dean of the National School of Tropical Medicine and Professor of Departments of Pediatrics and Molecular Virology and Microbiology at Baylor College of Medicine, and the Endowed Chair in Tropical Pediatrics and Co-Director for Vaccine Development at Texas Children's Hospital, titled "The Great Texas COVID Tragedy," be entered into the record.
Without objection.
Thank you.
The gentleman from New York is recognized for 5 minutes question.
Thank you, Mr. Chairman. Mr. Sauer, did you discuss the substance of your testimony here today with any members of this committee? Yes. Can you turn your microphone on?
I participated in a briefing yesterday afternoon with members of the subcommittee when my testimony had already been finalized.
And were any Democratic members included in that briefing?
I can't say for sure. I don't know all the members who were involved.
You don't know?
I don't know. I'm not as familiar with the membership of the committee as perhaps I should be.
And am I correct that, I'll just note for the record, there were no Democratic members in that briefing. But am I correct, sir, that you are one of the lawyers that brought the lawsuit that we are discussing here today?
That is correct.
So you're a party to that case?
No, I'm an attorney. That's very different.
Well, you represent Louisiana. You work for the Attorney General's Office of Louisiana, and Louisiana brought the case?
That's correct. It would be inaccurate to describe me as a party.
Okay. But you don't decide whether or not your arguments that you make in that case and that you're making here today are valid or not, do you?
They seem very valid to me. The judge will make a decision in our case.
The judge makes the decision, right?
Correct.
Not you. And as you know, the district court did not decide in its opinion whether your assertions are correct, right?
The district court dismissed the pending motion to dismiss by the Department of Justice, saying that we'd alleged sufficient facts to state claims, and we'll have a hearing in late May on our pending motion for preliminary injunction. He has not ruled on that yet.
Just so lay people can understand, a motion to dismiss just says that if the allegations that you make are true, you can continue with your claim. A preliminary injunction will actually address the evidence that you're discussing, right?
That's correct.
Okay. Now, are you expecting that the Department of Justice will appeal the motion to dismiss order?
You would have to ask them. Well, actually, the motion to dismiss order, it's very unlikely because there is no procedural right to appeal that. And so far, they haven't made any attempt to do that. It would be they would have to do that by pursuing what's called an extraordinary writ. That'd be very unusual. That said, I do not speak for them.
Do you read the news, sir?
I'm sorry?
Do you read the news?
Some news.
Are you aware of reporting that Donald Trump's defense attorney asked Republican members of the House of Representatives to intervene in an ongoing criminal investigation into himself in a local prosecutor's office?
I don't recall reading that.
Okay. If that were the case, would you consider that to be called, quote, directing, unquote, that the House of Representatives act on behalf of Donald Trump?
I would have to know many more facts before I'm able to make any kind of judgment like that.
Right. All right. Well, I just wanted to understand, because you talk a lot about directing here, that the government is directing, but then you also say that there's a compelling inference. Now, we lawyers understand that inferences only occur when you don't have direct evidence to support it, so I would also just want to note that.
We have
You know,
overwhelming
the sad,
direct and
there's no
indirect
question.
evidence.
The sad reality here is that we are continuing to go down this phantom narrative that the White House or the Biden administration coerce social media companies into censoring anti-vaccine and election disinformation and misinformation. Now, we know why that is, because the members on the other side of the aisle believe that that disinformation and misinformation, if it gets out there, is politically beneficial to them. But unfortunately, neither you nor they have presented any direct evidence to support this. But I would actually submit that this hearing is more notable, not because of the topic and the witnesses, including 2 who were too afraid to stay and answer questions, but because of what we are not focusing on. Apparently, this committee is no longer focused on the so-called dozens and dozens of FBI whistleblowers who were supposedly going to show some massive government conspiracy to attack conservatives. 3 of them have now come in for transcribed interviews over a month ago. Where are those witnesses, Mr. Chairman? Let's bring them in. Bring them in right here so that the American people can see for themselves what the entire basis of this subcommittee is. Now, you want to talk about censorship? You imagined in your opening statement a world where the FBI sends a list of books that should be pulled from their shelves. Luckily, we don't have to imagine that, sir. Are you aware that recent laws in Florida have resulted in the mass removal of books that are now banned in public schools?
I don't know about Florida. I do know that we have sworn testimony from FBI agent Elvis Chan that directly backs up the analogy I drew in my opening statement.
Okay, well, you should go look into this.
Expired.
You should go look into it because Florida right now is banning books, and you would agree that's a violation of the First Amendment.
Gentleman's time's expired. Gentleman's time's expired.
Can the
And
witness
since-
answer the question? Would
No, because you were
agree?
over your time. And because you addressed the chair, I'll tell you, stay tuned, Mr. Goldman. There's much more to come in this committee. The gentlelady from Florida, Ms. Kamik, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to our witnesses for appearing before us here today. I've heard your last name pronounced a couple of different ways today. How is it properly pronounced?
Seligman, thank you very much.
Seligman?
Seligman.
Okay, thank you, Mr. Seligman. You stated you are an expert in constitutional law, correct?
Yes.
Okay, excellent. In your testimony, your written testimony, which was provided to us late last night, it says that, quote, this is your writing, no government official ever threatened any social media platform with adverse action if a platform declined to moderate content flagged by the official or if a platform decided not to take an official's suggestions. Do you stand by your testimony?
Yes.
Okay. Now, a few minutes ago, just prior, you said that members of the legislative branch don't qualify for this particular statement, despite the fact that you said no government official ever. Does a representative in Congress constitute a government official?
Well, let me clarify my
Please do.
testimony from earlier. I don't think that legislative proposals that were brought by Republicans or Democrats constitute threats against social media platforms. That's true whether with respect to Section 230 reform. It's
Sure.
true with respect to antitrust enforcement.
So that would then lead us to the natural inclination to believe that you're talking about the executive branch, correct? Being government officials. So government officials like the Deputy Assistant to the President and Director of Digital Strategy like Robert Flattery, or the White House Senior Advisor like Andrew Slavitt, or the NSC staffer Katie Colas, or the Deputy Assistant to the President, or the White House Digital Director, or the Press Secretary for the First Lady, or the NSC Director for Counterterrorism, the Chief of Staff for the Office of Digital Strategy, the Director of Strategic Communication and Engagement, the White House Associate Counsel, Associate Director for Communications, the Deputy Director of Digital Strategy, and the Strategic Director of Digital Communications. Those are government officials, correct?
Yes.
Okay. And what's so interesting is that all of these members of the executive branch, all of them have communications, thousands of emails between them and Twitter and Meta officials where they demand that posts be taken down and censored. I'll give you a couple of examples, and then we'll see if you still feel so strongly about your words. January 23rd, 3 days after the inauguration, at 1:04 a.m., Clark Humphrey of the White House emails Twitter and says, "We're flagging this post for you. Hey folks, wanted to flag this tweet, wondering if we can get moving on the process to have it taken down, ... ASAP. Then, On February 7th, an email exchange took place between Twitter and White House Deputy Assistant to the President and Director of Digital Strategy, Rob Flattery, and asked for the steps that he could take to, quote, streamline the process for the White House's demands for Twitter censorship. Then 2 days later, on February 9th, 2021, he follows up again with Facebook with a more aggressive demand for more information, along with an accusation that would be repeated many times in the future, that Facebook was failing to censor speech on its platform, and it was causing, quote, political violence. Fast forward, you have March 15th, White House senior advisor then made an ominous statement threatening unspecified executive action against Facebook in retaliation for Facebook's perceived lack of cooperation with the White House's list of demands that have been documented and will be inserted into the record for this hearing on censorship of, quote, borderline content. The line that I think is particularly troubling is saying, internally, we have been considering our options on what to do about it. Do you consider that to be non-threatening?
I'm not familiar with the particular documents that you're referring to.
I just read you multiple examples.
Yes, and so I don't think that emphatic expressions of their concerns about the problem of misinformation is a threat. I don't.
So when President Biden says that social media companies are killing people, and then there is a direct line from the White House to the social media companies demanding posts be removed, going so far as to say there has to be a quick and devastating takedown, a published takedown, that is not a threat?
I don't believe so.
Wow.
I also don't believe it was a threat when President Trump made comments about social media.
I'm so glad we have this on the record. Again, my apologies to you, sir, for what you've had to endure here today. But with that, I yield back.
Thank you. The gentlelady's time's expired. Chair recognizes Ms. Hageman, Wyoming, for 5 minutes.
Thank you. Mr. Sauer, you and your colleagues have truly provided a great service to this nation by exposing what we can rightfully describe as the surveillance industrial complex, the censorship industrial complex, the corruption industrial complex. Take your pick. Your testimony today is stunning, as is your written statement, and I encourage everyone to read the information that you have provided. The breadth and scope of this vast censorship complex is stunning and extends from the halls of Congress to the executive branch to the office of the President of the United States. As one of the last questioners today, I want to give you the opportunity to speak directly to the American public, and I'd like you to give us examples of just one or two takeaways that you believe are paramount as we continue our work and as we seek to hold this administration and these corrupt government hacks accountable for their blatant violation of the First Amendment to the United States Constitution.
I would emphasize maybe 2 or 3 points. First, federal censorship activities are not in retreat. They are expanding. Federal executive officials are expanding the topics on which they seek censorship. It's expanding to more and more agencies, and it's expanding to any social media platform they can reach to. So we are not in a situation where this is something that occurred in the past. We have overwhelming evidence that it's growing and growing and growing, and there's little indication that there will ever be any voluntary relinquishment of the power to dictate what ordinary Americans can say on social media. So it's a problem that is growing. It's a looming threat. A second point that I would make is that censorship, as I said in my opening statement, both now and every other time when there's been censorship throughout human history, is not about truth. It is about political power. It's about obtaining power. It's about preserving power. And it's about expanding power. And the evidence of this, again, is overwhelming. You see it right there in the documents, some of which were just quoted. You see the White House saying, what we really want you to take down, Facebook, Twitter, and so forth, is borderline content. Borderline content that's described in the emails is often true. It's often true. It involves core political speech. We want you to take that down because that is what is most effectively undermining the narratives that we want to be out there on social media. That's an egregious violation of the First Amendment. It is viewpoint discrimination. I would also point out that Many of the comments that have been made on the other side today have said we can't let there be misinformation on social media because a tiny minority of the 100 million people who might see it might take it and do something bad. You might call that the minority report approach to the First Amendment. It's absolute poppycock. It turns the First Amendment absolutely on its head. The promise of the First Amendment is that no official, high or petty, will be able to dictate what Americans do. Americans can make their own opinions. They are adults. They can read the evidence. They can form their own factual opinions and their own opinions. And that is the core and the heartland of the First Amendment, which we see radically perverted in the communications between the White House and virtually every other federal agency that's discussed in my extensive written testimony. I would also emphasize censorship does not make Americans safer. It does not make them healthier, and it does not protect our democracy. Censorship is what kills, not freedom. Freedom is what preserves our liberty. Freedom is what makes us safe and healthy as a society. So this notion that we've got to have censorship because it's going to be a threat to our democracy, what could be more anti-democratic than federal censorship dictating what ordinary Americans can say on social media? The First Amendment in social media radically democratized speech. The First Amendment is the most pro-democratic political statement in history, perhaps, because what it says is every ordinary citizen can decide for themselves without interference from federal officials as to what their opinion is. And we can participate in a free market ideas with freedom of expression, freedom of association to engage in that. And that's what we see under direct assault by a whole army of federal officials in this case. And finally, I would emphasize that this should not be a partisan issue. Censorship violates the First Amendment no matter what viewpoint federal officials are going after. Everyone in this chamber should oppose the sorts of pressure, collusion, deception, all the things you see in our evidence in this case. Federal officials should not be in the business of saying what Americans can and cannot say on social media. And those are the conclusions that I would offer the American people.
Well, and again, thank you for what you have just described. What an incredible summary and a statement of where we are in this country. We appreciate what you've done, what you've been willing to expose. And with that, I yield back.
Thank you. The gentlelady's expired. I'll yield to myself 5 minutes as we wrap this up today. We've heard a lot. Mr. Sauer, what you just said was extraordinary, and I wish every American could watch that clip because you summarized it so well. I thank the gentlelady for giving you the opportunity. What you said earlier this morning summarizes it well also. You said censorship impedes the pursuit of truth in the free marketplace of ideas. That's the summary. Look, we brought in exceptional witnesses this morning. We brought in the Attorney General of the state of Louisiana and the former Attorney General of Missouri, now a U.S. Senator, because their litigation has revealed overwhelming direct evidence, as you pointed out, that the executive branch has undertaken a broad campaign to censor the American people. That's the headline. That's the takeaway today. Rather than one-off instances of censorship and coordination between federal agencies and the private sector, your case has revealed how federal agencies and officials have taken a whole-of-government approach to censoring online speech about topics that they think are disfavored. The federal government exchanged in two blatantly unconstitutional acts. First, they coerced technology companies to engage in censorship. They did this in a number of ways, and at least 20 officials in the White House itself were involved. Then the federal government colluded with the big tech companies and others to censor content. We know that federal agencies met frequently with social media companies and received internal platform data and other special privileges that empowered censorship. Third parties, such as certain nonprofit organizations, also worked as intermediaries to help the federal government effectuate its censorship scheme. This litigation in Missouri v. Biden offers the American people a unique window into the federal government's operation of what's now being called the censorship industrial complex. This litigation, led by Missouri and Louisiana, continues to unveil the extent of federal coercion and of collusion with tech companies to censor disfavored content. Of course, the censors have been wrong time and time again, but that's not the point here. The point we're trying to make is that the U.S. government is pressuring these platforms, which nearly every American uses every day, to censor speech. And whether you agree with the speech that's being shared or not, that doesn't matter. The only thing that matters is these actions are wrong and they have to be stopped. We have to protect the First Amendment and the free exchange of ideas. The gentleman here, the Democrats' witness, says in his closing statement, he quotes, he decries baseless conspiracy theories, end quote, and he says social media platforms must be, quote, uncorrupted by misinformation. But he doesn't seem to recognize how dangerous that position is. Who decides what is baseless and what is misinformation? You've provided, sir, a recipe for blatant viewpoint discrimination and tyranny. And I would suggest that you attend all of those mandatory First Amendment training courses that your dean at Stanford Law School has just been forced to order. I yield to Mr. Jordan.
Thank the gentleman for yielding. Mr. Sauer, did the government pressure social media to censor Americans for saying things like natural immunity is real?
Absolutely.
Did the government pressure social media to censor Americans for saying things like gain-of-function research happened in that lab in China?
Absolutely.
Did government pressure social media to censor Americans for saying things like the virus likely came from a lab?
That is right with the heartland of our evidence.
Did government pressure social media to censor Americans for saying things like getting vaccinated doesn't prevent COVID and it doesn't necessarily stop transmission of COVID?
Absolutely.
So all those were true statements, but according to the Democrats, it's fine for the government to pressure social media to take those statements down. In fact, this administration started doing that on day 3, January 23rd, 2021. Here's what the suggestion, as Mr. Seligman says, the Biden White House said to Twitter. Clark Humphrey, Executive Office of the President, White House Office. Hey, folks, wanted to flag the below tweet, and I'm wondering if we can get moving on the process for having it removed, then in all capitals, ASAP. Is that a suggestion or maybe something a little stronger than a suggestion from the White House on the third day, of this administration?
Stronger than a suggestion.
Heck yes, it's stronger than a suggestion. And here's the scariest thing of all. The bulletin the Democrats put up earlier, the National Terrorism Advisory System Bulletin for February 7th, 2022, talks about dis, and malinformation. Mr. Sauer, tell me what is malinformation?
Malinformation, by their definitions, is truthful information that the federal official thinks lacks appropriate context. It's an Orwellian term.
So it's true, but the government says we don't want the people seeing that, hearing that, repeating that, liking that, sharing that. We don't want that to happen.
Correct.
Now that is scary. That is exactly what the chairman just said. That is this dystopian, crazy world they want to go. And that's exactly what they were doing on day 3. Because you know what the underlying tweet was? The underlying tweet said this: Hank Aaron's tragic death is part of a wave of suspicious deaths among elderly closely following administration of the vaccine. He received the vaccine on January 5th. True. Hank Aaron, true and real American, great American, amazing athlete, wonderful human being. He got the vaccine on January 5th to inspire others to get it, and then there's nothing false in that whatsoever. Nothing false. And these guys in the Biden White House said, take it down, but not just take it down. They said, take it down as soon as you possibly can. That, and Mr. Seligman, Mr. Professor of Law, says, you know what? That's just fine. That is a scary, scary world that the Democrats want to take us to. And as you said earlier, if it was the other way around, if this was Republicans doing this to Democrats, you'd be here testifying too, and you'd be just as ticked off about it, and so would I. I yield back.
I thank the gentleman, the chairman of the committee, and we thank all of our witnesses for appearing before the subcommittee today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, this hearing is adjourned.